Texas Right to Life here. Wanted to give you a recap and an update on a critical pro-life case before the Supreme Court today. Today, the Supreme Court heard oral arguments in the Dobbs versus Jackson case. This is a critical case for the pro-life movement, and we were so excited to listen to the arguments this morning, and we're anxiously awaiting to see what the Supreme Court says, even though it's going to be months from now. But what this case was, is this was a challenge to a Mississippi pro-life law. Mississippi passed a pro-life law that banned abortions at 15 weeks. And the abortion industry challenged it, and it appealed all the way up to the Supreme Court. And the Supreme Court decided to take this case up. They don't have to take cases that are appealed to them. And when they do take a case, they identify one specific question, one very narrow focus that they're going to look at in the case. And so the arguments today were actually they were actually focused on the question of whether all abortion bans before viability are unconstitutional. So the question is whether states have the authority to pass pro-life laws that ban abortion before viability. Now, the background of this is that the Supreme Court has drawn this line, this artificial line of viability, and said that states don't have the right to ban abortions before viability, beneath that line. However, after that line, states do have the authority. They do have the right to pass strong pro-life laws banning abortions at the third trimester or other late abortions. Okay, so but that viability line, pro-lifers have known this, scientists have known this, doctors have known this, it's completely arbitrary. That line is nowhere founded in biology, it's nowhere founded in legal, legal theory, and it's based on some really bad ethics, a really bad ethical theory that we'll talk about. So, but that was the focus, is whether states should be allowed to pass bans like the 15-week prohibition or like the Texas Heartbeat Act, for example, that are beneath that viability ban, that viability line. Okay, so that was the focus. And Mississippi, the attorneys from Mississippi were arguing that they should throw that viability question out and allow states to decide their own rules, decide on what they want to do to protect innocent human life. And the Mississippi argued that the Roe v. Wade and Casey, Planned Parenthood versus Casey, these huge abortion cases that kind of frame, or the framework for judges when they consider if a pro-life law is constitutional. Mississippi argued that those cases, Roe and Casey, should be thrown out, should be absolutely overturned. And this is an amazing argument, because we actually haven't had this honest of a debate before the Supreme Court before. Ever since '73, we've been talking about undue burdens. We've been talking about how long it takes to drive to a clinic. We've been talking about precedent. We've been talking about all of these other things and not getting at the heart of the debate about abortion. And we were the closest to that today than we've ever seen. And that's why a lot of pro-lifers are extremely encouraged, because finally we're getting to some really substantial debates about Roe v. Wade and the subsequent case of Casey. Now, Mississippi argued, throw those out, because the viability line is bad logic. It's bad legal theory, it's bad ethical ethics, and it's not based on science. And so that's what the Supreme Court was hearing from Mississippi. But what they were hearing from the abortion industry was not a defense of why viability is a good line. The abortion industry just kept reiterating, we need a solid line, that don't overturn Roe. You have precedent you have to follow. Roe is the precedent. It's a watershed moment where in the court's history, don't overthrow it. But instead, this line is good. And they didn't really want to talk about the line too much, because it gets too close to the humanity of the child. And so they didn't talk about that viability line as much. They just said it is principled and it's workable. They just kept saying that over and over. This is a good, and we need a clear, principled, and workable line. And they just said viability is it. Now, really quickly, the idea of viability is that the child below this line is dependent upon her mother. But above this line, the child is more independent and has a higher likelihood of surviving outside of the womb. Now, this idea of dependence and independence is completely backwards of how we typically think about these things. And that's why I said earlier, it's based on bad ethics. When you think about your obligations to individuals, to people, to other people, whenever you see somebody who is more dependent upon you, like your toddler or a child, you actually think you have higher obligation to that person. Whereas if you see maybe an adult child, once they turn, a certain age, you kick them out of the house because you feel like you have fewer obligations to them, right? We do the same thing with individuals with disabilities. We think that because they are more dependent upon us, more dependent upon society, we owe them more. I have a higher obligation to those who are dependent upon us, and that's why we pass things like the American with Disabilities Act. We actually think the more dependent you are, the higher we owe, the more we owe to you, the more protection we should give you in the law, the more access, the more moral attention we should give you. And so we think actually those people who are most dependent upon you, they should get more protection, not less. But the court has actually said if you're dependent, if you're an unborn child dependent upon your mother, you get less legal protection from the states. Whereas if you're if you have above the line of viability and you can actually fend for yourself, you're more independent, have a likelihood of surviving outside the womb, then we actually can protect you. States can pass legislation to protect you. It's really completely backwards from how our kind of common moral reasoning works. But anyway, that's what was before the Supreme Court, and that's what they're going to be deciding in Dobbs. We want them to throw out the viability ban and throw out Casey and Roe while they're at it. Let pro-life states defend innocent human life in our borders. Not every state's going to decide to do that, but the states that want to should be able to. We have strong, compelling interests, really compelling reasons why we should protect those dependent, those vulnerable individuals in the womb. And so that's what this case is all about, is how much states can do protecting those most vulnerable and dependent unborn children. And so we really want this outcome to be giving states a green light to protect more innocent human life. So pray for the Supreme Court as they decide this. We probably won't get an opinion until June of next year, so it's going to be quite a while. But pray for a pro-life outcome, a life-affirming outcome in Dobbs versus Jackson, the case pending before the Supreme Court. This is a huge historical moment for the pro-life movement, and today the arguments were a really great outcome and really great kind of sign for the pro-life movement and what possibly could be coming in a Supreme Court ruling next year. So stay tuned to TexasRightToLife.com. You can follow us obviously on Twitter and Facebook, Instagram, all of the places to get updates. But the best place to follow us is to get our text alerts. And so what we want you to do is to text the word pro-life, all one word, pro-life, to the number 40237. That is the best way to get updates from Texas Right to Life and to stay tuned about what's going on with Dobbs, the Texas Heartbeat Act, and many other things that we're working hard here at Texas Right to Life, partnering with you to protect innocent human life from fertilization, even in those most vulnerable times before viability. So anyway, thanks for tuning in. Leave a comment and share this video if you think it was helpful explaining the Dobbs case and how it's such a good, promising case for the pro-life movement. All right, have a great day, guys.